Hello and welcome to the Disability Law Q&A with me, Martin Willemse. I'm a partner at the firm of Samfiru, Tumarkin, and the Western Canada Disability Practice Leader. So today we're going to have a discussion about all things related to disability claims. Please send in your questions via social media platforms. As they come in, I'll respond to them as best as I'm able to do. I'm going to start off today by speaking about something that comes up regularly, and that is the change of definition in group disability policies. What does that mean? Once you have employment and you have coverage for disability through your employment, in the policy, and this is a general statement because there are always exceptions to what I say, but generally, there would be two definitions for total disability. The first one would be that the person has to, or the insured, the employee, has to prove that they are unable to perform the duties of their own occupation, not job, their own occupation, as that occupation is performed in the general labor market. After a period of time, usually 2 years, sometimes 1 year, sometimes 3 years, but for the majority of cases, 2 years, the definition changes. Then the definition that the employee has to prove or the insured has to prove is that they are unable to perform the essential duties of any occupation for which they have the transferable skills. Now, that's where the problem often lies, and that's where the confusion comes in. Any occupation, let's start there. What does that mean? Any occupation does not literally mean any occupation. There are qualifications. The first one is it has to be something that the insured is able to perform within their functional restrictions and limitations. In other words, medically, they must be able to do that job. They should not be restricted or limited from performing such an occupation. Secondly, we have to look at, and the insurance company has to assess whether the person has the transferable skill sets to do such an occupation. They refer to education, training, and experience. Does the person have the requisite education, training, experience to perform such an occupation? And thirdly, there's a income level test. Some policies do identify the percentage level of what that new occupation must be able to produce to the insured in order to no longer be disabled or to be considered disabled within the meaning of the policy. Some policies may say any occupation for which you have the transferable skill sets that would pay to you 60% of your pre-disability income. Sometimes it may say your indexed pre-disability income. Other policies may say 50%, others may say 70 or 75%. I've never seen one really that as a higher percentage. In addition, if the policy itself is silent on that point, in other words, if there is no provision given with respect to the percentage, then we default back to the common law position, which usually would be 2/3 of the pre-disability income. So when we speak about the any occupation phase, remember it is not limited to, or it's not open to any occupation. There are qualifications. It must be something that the person is functionally able to do. It must be something that they've got the qualifications to do. And thirdly, it must pay them a certain amount of money, not the same as their pre-disability income, but a percentage of their pre-disability income. There's a lot more to be said about this. Often cases are denied at the change of definition because the insurance company may look at this as, are you able to work in another occupation? Because they're going to try and find the evidence to prove that. Because if they find that you are disabled into the any occupation phase, that phase for the most part is payable to the age of 65 should you continue to be disabled within the meaning of the policy. In other words, there's no more change of definitions. If they've accepted you're disabled, it's going to be more difficult to cut you off if there is no change in your medical evidence. So it is a point in time that is crucial to your claim where the insurance company is scrutinizing, are you still disabled? They often do something called a transferable skills analysis, where they communicate to a vocational consultant what your medical restrictions and limitations are. I often find that at that stage, when they do that, they do not always properly communicate what the restrictions and limitations are, which at the outset then undermines the opinion from the assessor. Because if they don't know what you can and cannot do, the ultimate conclusion doesn't make sense if the insurance company did not properly communicate what the person's restrictions and limitations are. Suffice to say, lots of cases in my mind are denied at that stage based on an unjust adjudication process. If that were to happen to you, if your claim is denied, do not simply accept that the insurance company is correct in denying the claim. If your claim is denied, reach out to us. We offer free consultations throughout BC. We've got offices in BC, Ontario, and Alberta, and we offer free consultations throughout the country other than in Quebec and the territories. So as you can see on the screen, you can go to disabilityrights.ca for more information. Okay, I'm going to get to some questions, and we may come back to this topic. JX2 says, what should you look for when getting life insurance? Okay, it's a good question. When trying to get life insurance, remember we deal at the end when there is a claim that is denied. I cannot give you advice as to how to apply for it, but I can speak in general terms. You may want to get a broker. You may want to get a broker who is not necessarily captured by one insurance company, a broker who will be looking at various products available through different insurance companies. If you do apply for life insurance, I can say to you what usually happens when a claim is denied and why they are denied. For the most part, these cases are denied because the insurance company may take the position, or likely will take the position if there is a denial, that when the person applied for life insurance, they did not properly disclose their medical history, their health history. Now, if you have a broker, you want to make sure that when the broker sits down with you and goes through the medical questionnaire with you, that you understand what those questions are. Because there will be lots of questions about your health history. There will be questions about, for example, have you ever had high blood pressure? Have you ever had an abnormal finding for cholesterol? Have you ever had symptoms or an indication of a mental health disorder? And they go through each body system. So if you make a mistake and if you were to pass away within the first 2 years of having coverage, the insurance company then at that point, depending on the insurance legislation in your province, may only have to look at whether the non-disclosure, they may refer to it as misrepresentation, was material to their decision to underwrite your application. In other words, to say, yes, we will insure you. If they may say, if we had known the proper information, we would not have issued the insurance, or we would have issued the insurance at a higher premium, or, well, I don't think that would be excluding conditions. Then you don't really have a leg to stand on. If the insurance had been in place for more than 2 years and then the person passes away and it is found that there was a misrepresentation, usually in that circumstance, the insurance company would have to prove that the person committed fraud, that it was a fraudulent misrepresentation, which doesn't necessarily mean that the person was just willfully doing it. They may also have been willfully blind. So it's a different test that is applied. The long and short of this is, when you apply for life insurance, the most important thing to understand is that you must disclose properly your health history, which may mean that you should go to your doctor and have your doctor go through it with you. Is one thing that I would recommend, so that you don't miss any of those questions and that you don't make an innocent misrepresentation, because that may still lead to a voidance of your coverage if you were to pass away within the first 2 years. We speak to lots of people with life insurance claims that have been denied. So again, if you have one of those, we'll offer a free consultation. We'll review the denial letter with you and discuss with you what the circumstances are, and then ultimately advise you of what your options are so you can make an informed decision. That applies to disability denials, life insurance denials, and critical illness denials. They're all different, and so many people get denied. And the best thing to do ultimately is at least speak to somebody who deals with this on a regular basis. You don't have to go through with any legal process if you don't want to, but at least you can make an informed decision, which in my mind is the most important thing. Okay. MedTech says, is it normal procedure for insurance company to make you use your medical EI benefits for 6 months prior to receiving STD disability benefits? It really depends on the wording of your policy. I've seen some unionized employers having different policies where it would be that you have to apply for medical EI before you can apply for short term. They sometimes call it long term or mid term, then it becomes long term. It really depends on the process and the policy wording itself. Generally, again, using that word, if you do not have short-term disability coverage, if you were to go off work, there would be a waiting period to apply for long-term disability, or at least before you can start to receive long-term disability. Most cases, the waiting period would be 119 days, so 4 months. In other cases, 6 months. I've seen cases where it's a year. I've seen cases where it's even been, I was looking at one this morning, of 64 weeks. In those cases, if the waiting period is that long, the person generally has short-term disability coverage. But for most people, yes, you apply for medical EI if you don't have short-term, and then it transitions into LTD where you actually have to submit the application within a timely manner because the policies have notice provisions in them. You have to submit the claim or at least provide notice of the claim and then provide proof of the claim within the specified periods. But in your case, if the STD, the short term, only kicks in after 6 months, I'm going to guess that there's some unionized situation going on. If not, have a discussion with the union. If not, you're welcome to reach out to us and we can have a look at your policy. Again, as you can see on the screen, you can go to disabilityrights.ca for more information. Okay, I'm trying to get through all these. So there's a question on Reddit from Turner. I'm partially blind and applied for disability benefits in Ontario. The insurance company said I might qualify for partial LTD, but I'm confused. Does that mean they'll pay me less or expect me to work part-time? As with every question, the most important thing to know is what does your policy provide for? Partial disability benefits usually would be a benefit that is provided in your policy. Not all policies have partial disability benefits. Some may provide that partial disability benefits are payable at 50% of insured monthly benefit. Others may provide that it's only payable for a certain period of time. The fact that you are partially blind should not lead to partial disability benefits. And I don't know enough about this, but I would want to say that just because the insurance company says you may qualify for partial disability benefits, look at things differently. You would have to look at what does the policy provide? Does it provide for total disability benefits? I'm sure it does. And if it does your condition, your disability, you mentioned that you're partially blind, does that impact you to the extent that you cannot perform the essential duties of your occupation? Total disability may be a misleading term. It doesn't mean that the person is totally disabled in the everyday sense of that word or that phrase. It means that the person is disabled from performing the essential duties of their occupation. They may still be able to perform most of the activities of daily living. They can get out of bed. They may be able to feed themselves. But if they have, for example, have a mental health disorder, may not be able to work with the public, may have cognitive impairment, etc. So it doesn't mean that the person is bedbound. It doesn't mean that they're comatose. It is specific to their job. So in the context of having partial blindness, if you're working on a computer, for example, that's part of your everyday duties, and your impaired sight prevents you from performing those duties, then you should qualify for total disability benefits under the policy. Again, if you have more questions, you're welcome to reach out to us. And if your claim were to be denied, contact us. We will provide you with a review and we'll discuss with you what your options are so you can make an informed decision. Okay, goodness, there's a lot of them coming through. So, first one, classic botanist, I like that name. I suffered an injury recently due to an unsigned road work. I have suffered a TBI and I'm struggling to figure out insurance/injury. It was a public road, so am I out of luck for any injury? Do I try to get on short term before I can start a long-term application? My doctors don't think I will return to work due to the extent of damage. Okay, so I don't know in which province you are. You should look at that, whether there is a personal injury claim to pursue against the governing entity there who was in charge of the unsigned road work. But secondly, which is much more to the point as to what we're doing. You say, do I try to get on short-term before I can start a long-term application? If you do have short-term disability benefits, yes, you should look at that and sooner than later, because again, there would be limitation period with respect to notice. Policies will provide that the insurance company must be provided with notice within a specified period of time from the date that the disability began. Short-term, much shorter than long-term. So look at that policy, speak to your human resources, and have them assist you in submitting a claim. LTD, you may as well speak to them about that as well. If yours is one of those where the short-term may only be 4 months, you want to know that you submit the application to the long-term disability insurer as soon as possible, that you do not miss the notice of claim provisions. Make sure that you have short-term disability benefits as well. Regardless of what you do, I would look at that if I were you, because you do want to get those claims in, so you do not want, so that you don't miss those notice provisions. I hope that was helpful. Okay. Navarro TT says, my mother is struggling with access to treatment. She doesn't drive and lives fairly remote. Her insurer is saying she isn't finding treatment and said she's going to be cut off. Is there anything she can do? She does what she can, but is not close to treatment, so she can only go a few times a year. Navarro, I'm so sorry that this is happening, and you may or probably will not be surprised how many times this comes up. In a system where the healthcare is in a state of crisis, where there are emergency rooms that are randomly being closed, where people wait weeks, months, if not years, to get proper access to treatment, it is very difficult to abide by the obligations under the policy, because the policies were not written within the real world context in mind, or at least if they were at that time, things have changed considerably because of the strain that the healthcare system is experiencing. Your mother should document everything that she does in terms of trying to access treatment. She should access, if she does not have anything in a local community, she should show to the insurance company how she tried to find resources in her own community, note them down, make notes of whom she contacted, when she contacted them. If the insurance company is insisting that she has to do certain things, maybe ask the insurance company if there is any way that they would be prepared to fund her travel to get to treatment. If your mother were to be denied, again, please have her reach out to us, because people do get denied at this juncture, or at least on this basis. Under the terms of the policy, there are certain obligations on the insured, in other words, on your mother. Those would include, number one, being under the regular care of a physician, and number two, receiving appropriate treatment for her condition or her conditions. That's called mitigation. Even if it's not in the contract, the insurance company may say that your mother, uninsured, has a duty to mitigate. What does that mean? It means that you have to take steps to improve, to take steps to get the best treatment available so that you can get back to work. If your mother is not able to do that, and it is due to no fault of her own, denying her claim on that basis, I think would be problematic. And I would highly recommend that if she were to be denied, that she contact us. But for the moment, those are the two things that I would recommend. And also have a discussion with the doctor. For example, I had a discussion recently with somebody else who was denied because one of the reasons was that she was not able to access a doctor in a very remote community. There are other options available. For example, online virtual visits. There are various companies offering those. But it was also problematic because you may be seen by a different doctor every time. But I would recommend, if that is the issue, that your mother is not seeing a doctor regularly, that she does that as well. Go online. There are various forums that you can try so that she can show she is doing her best to access the treatment that is available within a very compromised medical health system. Okay. Question on Reddit from Sam. I was approved for CPPD while on LTD. Now my insurance company says I owe them back. Can they really claw that money back? You know, CPP disability is always part of the discussion. You were recommended or you were approved for CPPD. You have to look at what your policy says. If it is a group policy, it very likely will say that the insurance company is allowed to use offsets when calculating the benefit. Those offsets would be monies that you receive from other sources due to your disability. In other words, income from other sources. The one that is basically always in discussion is CPP disability benefits. Another one will be WCB benefits, and then there are some others. But if the policy provides that CPP disability is an offset, then very likely, yes, you do owe the money back to the insurance company, the retroactive payment at least, if it overlaps the period of time that the insurance company paid you. There Not all policies have the same wording. Some policies may provide that if you refuse to apply or if you do not apply for CPP disability benefits or other sources of income for which you may be eligible or are eligible, then the insurance company will be at liberty to estimate the amount and automatically deduct it even if you do not apply. Usually they would advise the person to please apply, and if the person continues to refuse, then they may say, well, we're now going to simply estimate that amount and deduct it. CPP disability benefits, sometimes quite a controversial topic. I can speak to it in this sense. CPP disability benefits are paid by the federal government. The CPP disability criteria would be you have to prove that you have an illness or an injury that is number one, severe, number two, prolonged, and number three, prevents you from engaging in any gainful occupation. So that's an application that you make to Service Canada. If it were to be approved, you would get a monthly benefit, and it depends on various factors, but I think they're getting quite high these days, depending on what your insured income was. The benefit of receiving CPPD, on the one hand, it's taxable, which is not ideal. On the other hand, though, it increases every year. There's a cost of living allowance built into it. And for the most part, the increases that you receive from CPPD are not offset under the terms of the disability policies through the direct offset provisions. So there's a positive there. Secondly, it doesn't the once you've received it, once you've been found to be totally disabled within the CPP disability criteria, they do not assess it on an ongoing basis or as regularly as insurance companies do. So if the insurance company were to deny your claim, hopefully you'll continue to receive the CPP disability, or likely you will. There's also a child benefit that you could apply for. So if you have children under the age of 19 or older, I think under the age of 25, if they are still dependent on you because they're going to college or university, you could apply for child benefits as well, which will provide further income. Most disability policies provide that the child benefits are indirect offsets, so a different calculation is made. It's not deducted dollar for dollar, but at least there's that as well. So there is an income that could be coming in if your claim were to be denied. And finally, I would also say, even though insurance companies don't agree with this necessarily, the fact that the government approved your CPP disability application supports the fact that you are totally disabled within the meaning of the policy, both from the own occupation period as well as the any occupation period. So yes, the insurance company gets to deduct those benefits, but there are some positives to it as well. Hope that was helpful, Sam. Now, another question. Let's see if we've got some time. Yes, we do. Arcadia Design. I've been dealing with crippling anxiety lately. It's been a struggle day to day. Is it likely that I could get any sort of disability coverage for this if I need to take some time off to handle it? So first things first, are you employed and do you have disability coverage through your employer? In other words, is there a policy, you're paying premiums or your employer's paying the premiums? And if you were to become disabled, you would have either short-term, well, most people have long-term if they do not have short-term. Or maybe you're lucky and you've got short-term and long-term. So number one, find out whether you actually have disability coverage. Number two, if the question really more so relates to the actual condition. In other words, can you apply for anxiety as a disabling condition? Yes. The most important feature here is, I suppose the most important point is, many people have anxiety, yet they are able to work. But if your condition is such, and you're using the word crippling anxiety lately, so what I would highly recommend to you is see your doctor very regularly. I know having anxiety also impacts the motivation to actually go see a doctor, but it is crucial if you wanted to submit a claim. See the doctor on a very regular basis. Report to the doctor your ongoing struggles from an anxiety standpoint. If you have difficulty leaving the house, if you have panic attacks, other physical manifestations of anxiety, if it is impacting your sleep, your concentration, your focus, your ability to multitask, your ability to work with people, your energy levels, your motivation, fatigue, um, suicidal ideation, things like that, make sure that you report all of that to the doctor and the doctor understands what it is that you are experiencing. And importantly, that the doctor records those reports in the clinical records. Follow through with recommended treatment advice. So if the doctor is suggesting that you take medication, have that discussion. If the doctor is recommending counseling, which very likely will be the case, follow through with that. Access your extended health if you have that, so that you can show at your end that you are taking all the steps necessary to mitigate your damages. In other words, to get better. You're taking the steps reasonably required to get better so you can get back to work. If you keep your side clean, it's going to be more difficult for the insurance company to deny the claim. Also, when the doctor submits the attending physician statement, make sure that the doctor records why it is that you cannot work. As I said, lots of people with anxiety do work. So why can you not work? Of course, anxiety is a disabling condition and can be. So it's very important that when that is submitted, the doctor outlines why it is that this anxiety is so crippling and so disabling. And again, I will say if your claim is denied, please contact us and we can have a discussion with you as to what your rights are and what your options are. We're running out of time. I've got 1 minute left, but there's another question, so I'll try and deal with this. Positive Living says, my LTD will be ending in May 2026. Am I the one to send a letter to my HR office to request workplace accommodation with my doctor's note, or should my insurance ask for it? So have an ongoing discussion with your insurance company as to what happens. If it's running out ending May of 2026, I think a few things to be said about that. Why is it running out in May of 2026? Is that because the own occupation period is ending? Do not simply accept that that is incorrect. If you have any occupation phase in your policy, if the insurance company has already decided that the claim is going to end in May of 2026, it's too early now. I mean, it's only in October, so it's another 7 months from now. Have a discussion with your doctor closer to the time whether the doctor supports that you actually can go back to work, even in a modified way. I'm not an employment lawyer, so I think you should speak with an employment lawyer as well. And we do have sessions coming up on that actually Thursday, October the 16th at 1 p.m. Eastern Standard Time with Jeremy Herman. So pose that question too as it pertains to accommodations. But as I understand it, you should be communicating with your employer at least to provide updates as to what your ongoing restrictions, limitations are, at least provide notes. What I've seen in the past as well is if the claim does get denied, the employer may also reach out to the insured and may say, okay, well, we understand that it's denied. What are your plans? But I think more importantly, have a discussion with your doctor whether the doctor supports ongoing disability. Why is it denied in May of 2026? It's still months away unless it is at the change of definition. And remember, just because the insurance company says that you are not totally disabled doesn't mean that that is actually true. Have a discussion with your doctor about that. And if you've got more questions, you can actually reach out to our firm. Go to disabilityrights.ca. You'll see it on the screen soon. And we can have a discussion with you as to what your options are and maybe get a better understanding as to what's happening with you. With all of that being said, this brings me to the end of our session. Thank you for all the questions that came in. There were quite a lot of them. We'll do this again. Our next disability law Q&A will be on Tuesday, October the 28th, which is 10 a.m. Pacific Standard Time. So that would be 1 p.m. Eastern Standard Time. Thank you, everyone, and I wish you a good week. Bye-bye.